Hello and welcome to today's webinar, The Dark Side of Big Data. I'm Teresa Resick, Director of Webinars here at AIM, and AIM is your host and producer of today's event. With me today is David Horrigan of 451 Research and Jan Scholtes of ZyLAB, and ZyLAB is the underwriter of today's webinar, and we thank them for their support. And certainly thanks to you for taking the time to join us today. Before we get started, just let me give you some pointers for viewing today's webinar. You can download a PDF of the presentation at any time. And I do suggest that because there's some great slides in here. Just look to the small box to the left of your screen, click on today's presentation, then download files, and you can save it to your desktop. Feel free to ask questions throughout the hour using the Q&A feature. We will hold them till the end, where we'll have about 10 minutes to answer them. You can also use this feature to comment or ask for technical assistance. At the end of the webinar, we'll push out a survey link onto your screen. We would appreciate if you would take a few moments after the webinar to complete it, tell us how we did today, and to suggest future topics for us to cover. This webinar is being recorded, and it will be posted to AIM.org's Webinars on Demand in just a few days. Founded in 1943, AIM builds on a strong heritage of research and member service. Today, AIM is a global nonprofit organization that provides independent research, education, and certification programs to information professionals. AIM represents the entire information management community with programs and content for practitioners, technology suppliers, integrators, and consultants. Join us at the AIM conference that's coming up in March in New Orleans, Louisiana in the United States. A lot of great keynote speakers and several days of full conference materials, lots of good sessions in there. To get more information about our conference, go to aimconference.com and they'll be able to help you out there. The Certified Information Professional, or the CIP, allows individuals to demonstrate understanding of where their area of expertise fits into the broader information management picture. For more information, go to aim.org/certification. AIM is on Twitter, and so when you download the slides, get a list of our addresses, and follow the AIM staff to hear the different ways that we cover the information management industry today. I'd just like to take a few moments to introduce our speakers today. Jan Scholtes is the Chairman and Chief Strategy Officer at ZyLAB. From 1987 to 2009, Jan was President and CEO of ZyLAB. He has been involved in deploying in-house eDiscovery software with organizations such as the UN War Tribes Tribunal, the FBI Enron investigations, and thousands of other users worldwide. Before joining ZyLAB in 1989, Jan was a lieutenant in the intelligence department at the Royal Dutch Navy. Jan holds an MS degree in computer science from Delft University of Technology and a PhD in computational linguistics from the University of Amsterdam. As of 2008, he holds the extraordinary chair in text mining from the Department of Knowledge Engineering at the University of Maastricht, and he was previously on the AIM Board of Directors. And David Horrigan is an attorney, award-winning journalist, and an analyst on eDiscovery and information governance at 451 Research, where his research focuses on legal and industry developments affecting information compliance, risk, and governance. Prior to joining 451, David served as an in-house counsel covering media, technology, and intellectual property issues, and as a reporter and assistant editor at the National Law Journal. He was also a columnist at Law Technology News, where he co-founded the long-running Technology on Trial column. His articles have also appeared in the American Lawyer, Corporate Counsel, the New York Law Journal, and the Washington Examiner. He's also been cited in law reviews of Emory University, Northwestern University, and others. Quite the impressive legal research work there, David. So at this point, I'd like to turn things over to David to go ahead and begin our presentation today. David?
Thank you very much, Teresa. Jan and I are both very happy to be with you and your guest today. I think that Jan is going to kick off with some general observations of the dark side of big data. I'm going to follow up with some of the legal things that we need to consider when we're talking about big data and how we should all be handling it. Jan what's your thoughts, first of all, generally on big data, and then I'll jump in with some thoughts from the legal perspective.
Yeah, no, absolutely. Thank you, David, and welcome everybody. I'm also very happy to be here and to present today. We hear a lot about big data. A lot of companies are very excited about big data. They see a lot of opportunities related to being able to predict what's going to happen, find consumer patterns, find patterns of other interests, and in general, we share that excitement. But there is also a dark side to big data, and the dark side actually consists of different components, and many people that are collecting big data aren't really aware or aren't aware of the risks that they take by building these very large data collections. Now, first of all, in the unfortunate event that you get involved in litigation and you are going to be involved in a pre-trial eDiscovery, or you get investigated by a regulator, regardless whether that's in Europe, Asia Pacific, or in the United States, all of your data is going to be used in this litigation or investigation process, also obsolete and useless data. And as a result, legacy data can become a critical part of litigation, and especially if you, for instance, old Lotus Note servers or other systems that are not like state-of-the-art, and maybe they're not even under maintenance, you can run into a problem of having very high access costs to access this data. And if you need to disclose it, you need to disclose it. And these days, lawyers and judges and opposing parties are less and less sensitive, or less and less willing to define that certain data is just out of control. You just have to collect it, and you have to bear all the cost. What we see in general is that the cost of eDiscovery are highly determined by the amount of data that you have, regardless what's in that data. Now, on top of that, we see hidden compliance risks. If you collect a lot of big data on consumer patterns, spending patterns, other data, sales data, it could very well be that you are unintentionally violating privacy and data protection acts. It could also be that you have data which contains evidence or other information related to FCPA, bribery, export controls. It could be that what you did, for instance, 10 years ago was not illegal or was fully allowed by law. Today, because of new legislation, it is no longer legal to keep such data, or it's no longer legal to do such things. Now, if you are allowed to remove this data by law, keeping it can be very dangerous. And the last reason, and this is primarily what is of the concern of IT, is if data is misplaced on your network system and it has the wrong access security rights, you can run into all kinds of problems, from intellectual property theft and also to fines and sanctions related to privacy violations, data protection violations, etc. And those three reasons we see are really the core of the dark side of big data.
Excellent. Thanks, Jan. You know, before we get into a discussion of some of the specific legal and international issues, I thought it would be good to take a look at basically how we're dealing with the problem today. At 451 Research, we concluded at the end of the year with a survey that we did of about 2,300 users across various size enterprises and various job descriptions. We interviewed people from just on the line working, on to middle management, to IT professionals, to executives in the C-suite. The overall importance of information governance was at 42% of the respondents finding it very important. So that's less than half. Somewhat important was 26%. Not very important was 12%. As you can see on the slide, not at all or don't know was 21%. We weren't exactly surprised with that level of there, but as we go on to the next slide, here's another one that also was not much of a surprise. If you look at the data here, you're seeing a linear progression on how important people thought information governance was. If you look at the far right side of that matrix, the organizations with over 1,000 employees thought information governance was very important. You've got 65%. But look at those numbers just reduce in a linear progression. as you get down to the smaller organizations with between 1 and 10 employees, and only 23% of those respondents found information governance to be very important. Later on during our presentation, we're going to point out why that's a real problem when you get into social media, mobile data, where this information and this big data issue is not just for big organizations anymore. Moving on to the next slide, here's another one that we found somewhat surprising and, frankly, somewhat troubling. We've got the percentage varies based on job description of how important people thought information governance was. Not surprisingly, the IT management and staff, more than half, thought it was very important. Mid-level management, a little bit less at 46%. But look at those senior executives. The C-suite, we've only got 32% of them finding information governance very important. Now, to the members of the executive suite on this call, senior management, I would take a look at that and see if that's how you feel. I think those of us who work in this field all the time, if you were to ask us, well, of course information governance is important, and of course everyone gets it. That's not the case, as these data show, I should say. And so as we look at this, as we go throughout today's presentation, we need to keep in mind that in handling big data, there's a lot of evangelizing that needs to be done, and we've really got to get the organizations on board to even really consider this much of a problem. And Jan, any thoughts on that?
Sorry, I was still on mute here.
No problem.
No, well, this is interesting, and it's actually interesting for a couple of reasons. Because we see that the most successful projects where people actually address the dark side of big data are those projects where there is support from the top. Where there is like a direct connection or a direct line to the CEO's office or to anybody in the top of the company that feels responsible. So this may also have to do with the fact that not many companies are taking the dark side of big data that serious. Having said that, more and more are. So I would be very interested in seeing the results of this survey if you would do it again in like a year from now and see if there would be any changes.
We're absolutely going to be doing it again, and we're also going to get a little bit more granular to get more data on this. So, and we'll be issuing 451 research reports on that, so we'll definitely be following up.
Yep.
And then, eDiscovery being less of a mystery, understanding the obligations under eDiscovery and eDisclosure. For those of you in the U.S. audience, eDisclosure is simply the term used in the United Kingdom and some other jurisdictions referring to what we in the U.S. call eDiscovery. And some of the things that we want to see, some of the things that we see maturing are the affordable, straightforward, end-to-end eDiscovery applications that are available. It used to be that you would go and you would see various vendors with very specific products spanning what is called the information, I'm getting ahead of myself, the electronic discovery reference model. That's morphed into the information governance reference model, and we'll talk about that a little bit later in the hour. Less mystery in eDiscovery. And then the key thing is 100% defensibility if you've got the right applications. There's some fear of the black box, things you can't explain, because, frankly, a lot of lawyers didn't go to law school to be technologists. A lot of paralegals are very well versed in this. Obviously, the IT staffs are involved in this. So as part of this whole concept of dealing with big data, we've really got to get on board with everyone working together, because that's the only way we're going to solve the problem. It may sound trite, but it's a real issue, especially if you look back on that data and how important people are finding information governance. When we get into the legal issues, we've got some key issues we've got to keep in mind. One is the choice of law, which law applies. And as litigation becomes increasingly more international, that's a real concern. Retention policies are very big. We're going to be talking about some case law in a few minutes that will really hit that point home. Legal hold requirements are another big one. And then the results of bad retention policies and insufficient legal holds are spoliation and sanctions. For the non-lawyers in the audience, spoliation is a legal term, meaning basically the destruction of evidence that is required in a court case. It's no coincidence that it sounds, just remember, it's like spoiling the evidence, spoliation. The international aspects are very important, and for those of you who have dealt in international litigation, you've dealt with these. You walk into a United States federal court, and there is a broad-based discovery request. When you get that discovery request under the Federal Rules of Civil Procedure, you may end up producing a lot of data. This was a problem before when you were producing a few banker's boxes. When we get into the realm now where we're dealing with terabytes of data, it's a huge problem. And if you think about the dark side of big data, this is one of the darkest sides, the sheer amount of it. And obviously, big data itself is a somewhat nebulous term. It means much more than just a lot of data. It's the ability of your infrastructure to handle that data. You've got structured data, semi-structured data, unstructured data. The semi-structured data is like email. It has a lot of text that's not in a structured database, but then again, it has certain structured aspects such as the metadata inside it. When we get into these broad-based discovery requests from the United States, they run smack into opposition from European law. Many of you are familiar with Directive 9546/EC of the European Parliament. It's commonly known as the EU Data Protection Directive, and it's often in conflict with the U.S. Federal Rules of Civil Procedure. So you've got a U.S. court saying you've got to produce this. You have European law saying, you know, you can't do this. And if you look at the federal rules, the courts have interpreted Federal Rule of Civil Procedure 34A1 very broadly, anything under a party's possession, custody, and control. Well, if you look at some of the forbidden personal data under the EU Data Protection Directive, it's equally broad-based in what you can't produce. So these two laws and regulations are really in opposition much of the time. The United States Department of Commerce, a safe harbor, you may have heard of that. That is an ability in the United States to have your organization be seen under European law as having adequacy standards for data protection. That's not a one-time deal where you can go into the Commerce Department in the U.S. and say you qualify. It requires annual updates, and it's a way to sort of harmonize the law. Another issue, when even getting beyond the EU Privacy Data Protection Directive, are European member state blocking statutes. In addition to this EU directive, each of the individual member states can have its own laws and regulations dealing with personal data. The blocking statutes in France, are much stronger than most data protection laws in the United States. And so that's something to keep in mind. As many of you know, there are proposed European Union general data protection regulations being discussed and debated at the present moment. One thing to keep in mind from a U.S. audience is the difference between the directive from 1995 and what's a proposed regulation here. Under the EU law, a regulation is much more binding on the 27 EU member states. And the idea behind this really is to harmonize the data protection rules among the 27 member states, as opposed to a directive which gives the member states much more leeway. So it could be helpful to have a regulation as opposed to the 1995 directive. The problem for international litigation is that the United States has different regulations, and they are much more piecemeal. U.S. audience members might not want to hear it as piecemeal. They would say it's tailored towards specific industries under the Federal Trade Commission. The Europeans would see it as completely insufficient to do what the EU regulations do. So I would encourage you to follow the debate and the continuing proposed implementation of this general protection regulation, and then on the U.S. side, follow what's going on with the Federal Trade Commission, because those are issues that could be opposed to each other, and harmonization would be great, but it's going to be a difficult process, I think, for international litigators. As we move into some of this United States case law, this is where we take into account some of the issues we've been talking about under choice of law, the legal holds, and the various issues that are going to affect you as you try to deal with big data going across the pond. Victor Stanley is a case from a few years ago many of you may be familiar with. In this case, there were damages placed against a party for spoliation for over $1 million. Those were later overturned. There were criminal sanctions also, and the criminal sanctions were overturned, but substantial penalties in this case for noncompliance and basically destroying evidence. So Victor Stanley stands for the proposition that you really need to watch when you're destroying evidence. And, you know, one thing in the 2010 opinion, there were subsequent opinions after Magistrate Judge Grimm made his decision. If you go to that 2010 opinion, there's a great compendium of spoliation sanctions in different jurisdictions across the United States. I'd encourage you to take a look at that. Granted, it's a few years old now, so you'd want to do your research and update where those cases have gone. But Judge Grimm did a very helpful thing by putting that in there, especially for our European neighbors who, look, my gosh, you know, the European Union has 27 members, but we're dealing with 50 states here. And so that's a good thing to keep in mind. Moving on to Chin v. Port Authority, this is really the issue of a legal hold. You may be familiar with Judge Schindlin in the Zubilate cases in the middle of the last decade. Pension Committee, the first case under Chin, was sometimes considered the Zubilate revisited. And basically, Pension Committee said that you had to have a written legal hold. The failure to do so was per se gross negligence. And that was a huge issue because, frankly, a lot of organizations weren't doing written legal holds. Orbit One Communications, and the reason you see Pension Committee and Orbit One underneath Chin is that in the United States, the New York Federal District Courts report to the Second Circuit where Chin was heard. The Second Circuit is an appellate court. And Orbit One basically took the opposite position of Pension Committee, saying that, you know, a written legal hold is great, but it's not per se negligence not to have one. The evidence that is not subject to the legal hold must be relevant to the case. So it's a little bit of a safe harbor. If you have failure, if you've not issued a written legal hold, it's not negligent if the items that were not preserved were not pertinent to the case. Chin took the Orbit One position. Obviously, it's not a green light to go and not have written legal hold. It's merely saying that it's not per se negligence. So keep that in mind. When you look at Chin, Pension Committee, and Orbit One, think about how your legal hold is operating. Obviously, litigation technology software plays a big portion in this because now this process can be automated and be defensible as you have software to take you through the entire life cycle. Micron is an interesting case. You see the other one, Hynix Semiconductor. It basically deals with the same fact pattern. It's a patent dispute with computer software and hardware makers. And in this case, Rambus had, quote-unquote, shred days. That was their information governance plan. You know, it was legacy data that was gone back. The only problem is in these two cases, the court was saying that there was a reasonable expectation that litigation could ensue. Thus, there was an obligation to have a legal hold. In essence, you shouldn't be having shred days. The Hynix court and the Micron court and the lower courts came to different conclusions about whether when Rambus was having these shred days, they should have been aware of what was going on with the litigation and thus not had the shred days. But finally, it went up to the Federal Circuit, which remanded it to the District of Delaware. These were patent cases, and the intellectual property patent cases in the United States go to what is called the Federal Circuit. And in this case, it was found that, yes, in fact, Rambus should have known at the end, and they shouldn't have had the shred days. And the penalty for that was that their patents were unenforceable. So it's a huge penalty in this case. Once again, hitting back home the point, think about your legal holds, think about the spoliation of the evidence because it could have serious consequences. The Hallmark Cards v. Murley case is an interesting one. It's actually a non-compete agreement with a former employee. And the employee, Murley, basically destroyed documents, got rid of them on her hard drive right before they were to be subpoenaed. This case hits home a couple of good points. Number one is BYOD. One of the issues with big data is the question of whether or not you can actually control what employees were doing. If the lawyers were running everything with their IT departments, they would lock down everything. You wouldn't have USB drives. You wouldn't be able to carry stuff out. But that's not the way people work. We have an increasingly mobile society where people are used to BYOD. People are used to collaborative working. So the lawyers aren't going to be able to lock down things. But just remember, that stuff's walking out the door, and the Murley case shows us that. Lester v. Allied Concrete is another interesting case, and that brings in one of the big issues that's affecting us today, and that's social media. In this case, it might be something that you wouldn't even consider to be that nefarious. The lawyer telling his client to clean up his Facebook page before the stuff has to be produced. However, it's completely unethical and a complete violation, and it learned the hard way. The judge ordered the lawyer to pay $522,000 as a sanction for instructing his client to remove photos from his Facebook page. It was a wrongful death case, and among the things on his Facebook page was a T-shirt saying, "I, heart symbol, hot moms." And this is a plaintiff who is in litigation over the loss of consortium and his devastated feelings over the loss of his wife. Now, this is not to say that the gentleman wasn't devastated over the loss of his wife, but boy, you put that picture from a Facebook page in front of a jury, and it leads to problems. I think the case illustrates, first of all, that Facebook and social media really affect small cases. When we think of eDiscovery, we wouldn't have ordinarily thought about a case with one plaintiff in a wrongful death case, or a slip and fall case, or a matrimonial case. Social media is changing that. eDiscovery is becoming a big issue. And in this case, you've got social media affecting the case, and then you've got the lawyer making an improper instruction. You can't be telling your clients to go clean up their Facebook pages after the fact. So I think when we look at all of these cases in total, it really hits home the point that big data does have a dark side. It's got many benefits. It increases the way we can be productive. It helps us in our lives. But dealing with it from a legal and eDiscovery standpoint, there are some issues. And I think Jan's going to take us down some of the technical issues that we're going to face as we get on from here.
Yeah, no, absolutely. Very interesting, David. Thank you for that very thorough overview. What we see happening is that now that organizations are taking control over their eDiscovery data, and that's what we see happening because eDiscovery is becoming more clear. All the case law show us what we need to do, what we cannot do. Companies like ourselves, we have written like a whole methodology, best practice that goes with our software, including templates and guidelines and report examples on how to make the whole process, how to keep the whole process defensible, even if you do it in-house or if you have the data control over your data in-house. And what we see, there's a couple of benefits. First of all, if you own your data, you control your data, you can provide access to these document collections for third parties, so your law firm and your forensic accountant can actually access the data from their locations. You don't have to give them the data. It also gives you the flexibility to use different law firms, multiple law firms. It's easier to review data even from different parts of the world. You can measure productivity, and at the same time, you can also run your own early case assessments. You can do your own analysis. You can try to find documents that will help your different legal teams to negotiate settlements. So it's all very useful. So what we see, it's an absolute no-brainer that taking the control over eDiscovery data is what every company and government organization these days is doing, because there's a huge return of investment. Now, once these companies have deployed the software and they've trained their people and they have deployed the methodologies and everything's up and running, that's when we see that after that moment, there's really no excuse for them not to also start looking at implementing more proactive programs. Because what you've shown with your case law is that if you have a lot of data, this data can all become part of litigation. Also, there could be data that you may have destroyed or retained under normal records management practices. Suddenly is becoming part of all this litigation. And regardless of what's in it, you have to look at it and you have to involve it in the lawsuit, and it's costing you a lot of money. So what we see is that companies that do have these in-house eDiscovery systems and skills, they start at a certain moment implementing also more proactive programs for governance, regulatory. They're going to clean up data. They're going to when there's a migration, a cloud migration, other thing, they're going to do risk analysis, and there's really no excuse not to do that. Now, where are these risks? We talk to our clients. This is where they tell us that their concerns are. Of course, in the center, there's the concern for civil litigation, intellectual property. A lot of the cases you just talked about were IP cases, HR cases, like in the case of Hallmark, class act, shareholder liability, etc. But what we see is that this is not the only problem. Civil litigation, of course, being very strong in the U.S. and also being a big problem for European companies operating directly or indirectly in the U.S. But there's also a lot of other concerns. Like in Europe, one of the big concerns of companies is antitrust competition investigation from the European Commission, privacy regulations, frauds, violation of export controls, FCPA or UK bribery investigations. And more, we also see human rights, employee workplace safety and environmental issues becoming an issue. And all of these can result in being investigated or being part of a pretrial discovery. And really today everybody should think about how can we take control over our eDiscovery data, and you can either buy the software, install it on premise, or you can rent cloud-based software, private cloud of course. This is where you will have your largest ROI, and we see that with our clients. The typical ROI, return of investment, is just one large case. Now next, you can start looking at legacy data cleanup. You can start looking at data risk analysis and data security, and try to address the dark sides of big data. Now, before you do this, you have to make sure that all of these stakeholders are aligned, because as David said, lawyers want to throw away everything. IT is primarily concerned about security levels. And networks and storage and duplicates. They don't really look at the content of data, but the business who owns the data wants to keep it forever, just in case they ever need it. And then there's this whole new number of people that are compliance and data protection officers. There's a whole new set of job titles that suddenly are aware of all these risks and want to address them. Now, what we see is that in order to do this, you need to have everybody on board, because the business is not going to allow you to destroy or delete the data, transfer the data, unless they're 100% convinced you're only going to throw away the stuff that they no longer need. Also, legal wants to be involved, because you don't want to throw something away which is under a legal hold or which you have to keep for regulatory reasons. And we see more and more organizations thinking about a job title called Chief Data Officer. I've seen some very interesting job titles recently, going from Vice President of Legacy State Systems or Data Risk, Vice President of Data Risk Analysis. And all of these new job titles are in companies where people are aware of the risk and they're trying to address them. Now, if you do use state-of-the-art technology in order to automatically classify and identify documents of different categories, you can highly reduce your data volume. And because of Moore's law, data volumes just continue to grow exponentially. So what's very interesting is the earlier you throw data away, the less it can contribute to the exponential effect. So you can see here a graph with a dark blue area, which indicates the amount of data that you have after you consistently throw away data, and then the light blue one is the one that shows the accumulation of data if you don't do anything. And this is actually real data from real projects we did with clients. Another thing you should think of or be aware of, that if you are going to migrate your legacy systems and your legacy data into new formats, new software, new servers, it will also save you tremendously on the maintenance and support contracts for these old systems that can be very, very high. Because in general, the older the system, the more maintenance you pay. Now, what's a good moment to start these legacy data cleanup and data risk analysis projects? Typically, when you do a data center consolidation or server consolidation or cloud migration or server virtualization, or this is another thing, a lot of companies buy other companies. Now, if you buy a company in acquisition process, you also often buy a lot of old servers. And when you buy a company, a lot of people leave, and it could very well be that the people that know how these servers work also leave. So we have many clients that use this technology to clean up data and migrate it into central repository after acquisitions. Or if you shut down a plant, The same story there. If you shut down a plant or a company, it could very well be that you have to keep a lot of the data for regulatory reasons, but everybody's left. So how do you keep track of the data? Software maintenance consolidation, post-litigation, and as part as an ongoing records management initiative. Now what we see is that there's two approaches. On the left side here in blue, you see the typical reactive litigation response approach, where eDiscovery in the US, as David explained, is a very process-driven activity. You have to follow the rules, you have to follow the best practices. It's really about these rules and these best practices, and if you make errors, you get sanctions, fines, or you're being accused of spoliation, or you get like a negative verdict. On the other hand, there's the orange part, which is more like the litigation readiness, where you want to be prepared and you want to apply retention and disposition. Now, what we see is that a lot of companies, most of our clients, about 80%, is on the left side of this graph. And it's very hard to convince them to start doing, being more proactive, be more litigation ready. The process is explained on the right side of the graph. But what we see that once that people have or suffer a lot from litigation or from investigations or because they're in a highly regulated industry, then, and they have brought this eDiscovery tools in-house and they know how to use them, then it's a very small step for them. And it's also a great opportunity to be like more and more proactive, to start doing regulation enforcement, help with the introduction of new regulations, analyze data, do contract policing, data monitoring, start implementing programs for defensible disposition or other GRC projects. Now, how have we seen this with our clients? What you see here is a schematic overview of typical process where, as part of a server migration or consolidation of servers, this is typically what our clients do. They create a project plan, they identify where the data is. This can be automatically done or through workshops or interviews. After the identification, they use our technology to collect the data, to process it, to classify it. The classification, of course, is done automatically. They do a quality control, and then the system actually generates a number of reports. And these reports then show the user, where the data is and what actions that they should take. And actually, if you are familiar with the EDRM model and eDiscovery, this is a very similar process. And we see that our clients are able to do these legacy data cleanup and defensible disposition processes with exactly the same technology, exactly the same tools. And it's a slightly modified process. And the good thing is it's without the risk and without the deadlines. You much rather do these exercises and clean up and analyze your data without all the pressure of deadlines and judges and juries and opposing lawyers looking over your shoulders.
And Jan, that's a really important point you make there. As we look at this chart here, this is one put together by Ralph Losey and his eDiscovery team. This is the electronic discovery best practices, and many of you are familiar with the EDRM. So as you look at this chart here, it's a little bit different as it includes what lawyers would actually be doing, what the paralegals and what the IT staff will be doing throughout the process. In addition, you've got some important things in here. Look at that red box in the middle, cooperation. That's inserted, and that's really important. Many of you are familiar with the Sedona Conference, a think tank that makes recommendations on the legal and technical issues of electronic discovery. And they've issued the Sedona Cooperation Proclamation. And many courts have, I shouldn't say many, some courts have referenced that, and more courts are taking that into account because they just want this process to be cooperative. And that may sound trite to a certain extent, and it is an adversarial system where you have lawyers going up against each other and clients going up against each other. But as far as the electronic discovery process, that is something that you can have parties agreeing on. Predictive coding and technology-assisted review has become a huge issue over the past year and a half. And one of the cases that has been cited, NRE Actos, a pharmaceutical case in the United States, had a large protocol established pre-trial onto which the parties agreed. That sort of thing is incredibly beneficial so you can do the electronic discovery and then move on to the merits of the case. As we go on beyond the electronic discovery best practices, Our next slide shows us the Information Governance Reference Model. This is actually put out by EDRM. And note the first thing you see about this is that it's a circular business process where you've got business, IT, legal, and risk management all working together throughout the process. As Jan said, what you're striving for here is a proactive information governance process instead of reactive eDiscovery. If we go back to our previous slide on the EDRM, notice how information management is just a small feature on the far left side of your screen. Then you're through this linear process of going through eDiscovery. The problem with this linear process is it's a last-minute fire drill. You've got the regulators knocking at the door. You've got opposing counsel demanding documents. And this thing is done very quickly oftentimes. It drags out, but the deadlines are always there throughout the process. And what that does is make it very cumbersome and extremely expensive. You know the stories of the IT staff and the lawyers and paralegals working all throughout the night to make these last-minute productions. If we move forward then, back to the IGR, too many acronyms, IG reference model, the IGRM. Notice once again that this is a process that continues on throughout the process. So as Jan said, it's not done at the last minute. You've got everyone working together. In the EDRM, that's pretty much the lawyers and the litigation technologists as opposed to the regular IT staff. This is an effort to get everyone involved. And taking back to what we talked to about the beginning of the hour, how different stakeholders see information governance as less important or more important, the idea behind this is to get everybody on board, everyone working together through a cooperative process, so you just don't have those last-minute fire drills. And I think Jan's going to take us through some more technical solutions.
Yeah. I just got a couple of examples to make this a little bit tangible on, how do you do this? How hard is it? How much is automated? And what you see here is just an overview of how technology can identify and collect information from many different locations. Data can be in file systems or in email or in SharePoint or in the cloud in Microsoft 360 or in Google Docs Enterprise. Now, for instance, with our technology, we can collect data from all of these different locations to a location where you can either use it for eDiscovery or you can temporarily store a copy and do some in-depth processing and assess the content of the documents. Now, typically what you want to do in a legacy data cleanup operation or in a risk analysis project is you want to classify your documents, you want to sort them. Where under eDiscovery you want to sort your documents in categories like confidential, privileged, responsive. In the case of document legacy cleanup, you want to say, okay, which data do I need to keep because of regulatory obligations? Which data do I want to keep because I need it for my business? And which data do I need to keep because it's under legal hold? And what can I do with the rest of the data? Actually, I can just throw it away. And typically these are the three main categories, and each of these categories has a number of subcategories. Now, every company has these type of categories. They were called filing plans these days. They're called retention policies. And once you have a rough structure of a filing plan or an overview of your departments, or you can do it by the department or by the server, you can actually use technology to automatically classify documents. You can do that by using full-text queries. There's a couple of examples here. You can use wildcards. You can use regular expressions to identify documents with credit card numbers or social security numbers or other information that might be private, personal identifiable information and therefore a violation of a Data Protection Act. But as a couple of examples, you can also classify documents by department. Because certain documents for certain departments need to be kept longer than other documents or other subcategories that have a certain type of refinement. And it's very easy to classify documents, for instance, from legal departments, from projects, from operations, but also from finance. You can do the same by actively identifying spam or actively identifying documents that are workplace records or documents that are personal records. And by using all these different dimensions and using all these different categories, you can actually assess data from different angles, and you can sort and classify your data. Here's another example for instance, the document security level. And by doing this, which is an interactive process, and by generating reports that show you how old data is, where it is, and by mapping it against a filing plan or a retention policy, you can actually do like records management after the fact. Because that's what we're doing here. Like 10 years, 20 years ago, every organization would have a records manager, and a records manager, when you create a document, you would have instructions from your records manager, and when you create the document, you would set a classification level, you would set a retention period, you would say where it fits in the filing plan, and then the archiving or records management department would take care of the retention policy later. Now, these days, organizations no longer have records managers. There's a lot of electronic data which is created without assigning it into part of the filing plan, without indicating a retention policy. So we see many organizations having terabytes of data in file shares and SharePoint collections that they now need to classify, and it's impossible to do it by hand, but very fortunate technology is here and can help us to do these processes. Now, one of the things that's very important here, and this is something you should agree with your auditor or your records manager or your other internal regulatory authorities, is if you use automatic technology like I just showed to automatically classify documents, you need to do a quality control. And one of the things to do a proper quality control is to take a random sample from your data, 1% or 10%, whatever you agree with your auditor, and then check if all of that data is properly classified. Now, if you, for instance, have 80 or 85% proper classification, you are reaching the same levels of quality that what you would have if humans would have done this classification. That's like a general benchmark. So what you can agree with your auditor is like if 80% of your documents or more are properly classified of your random sample set, you can presume that everything else has been done as well at the same level of quality. And then your auditor can give you permission to use automatic tools to destroy, transfer, or retain or file these type of documents. And there's an example here of such a process. We've made it very easy in our software. You can actually see during the validation of your sample set what is your best case estimate that you're going to make. So if at a certain moment the quality of your automatic classification is too low, you're getting less than 80%, what you do is you go back to your rules, to your automatic classification, you fix the errors, you change it, and then you do your whole classification again. And typically in 5 to 7 cycles, we see that people can write rules to automatically classify documents very, very reliably. Now, the next step, and this really is what we see after bringing eDiscovery in-house and after doing these legacy data migration or legacy cleanup projects, the next step is where people say, well, now I want to also make sure that whenever I transfer or analyze this data, is there anything in there that I should be worried about? Is there anything in there about bribery or about fraud or about privacy risks or data protection risk? Now, here's where we can use our more advanced technology, our text mining technology, where we can actually look for sentences or for certain patterns. And in this case, what we can do is we can actually find patterns where a person is offered or received a trip or a meeting in a particular country. And we can define these patterns very general and very high level, and then the computer will automatically find sentences like, we're pleased to offer you a complimentary trip to Thailand, which may be reason for you to do some additional investigation why people get these trips. Or you can say, well, I'm interested in people buying or offering certain things, or I'm interested in certain networks. And this is really the next step, and we see more and more organizations looking into this. Now, having said this, how can you do this? How can you bring this on in-house? Now, the easiest way is to buy our technology. And we have full in-house deployments of software together with professional services to do this in-house. And then you can run as many cases and as much data as you want. And when we have clients processing many terabytes of data a day, we have clients with more than 1,000 lawsuits a year that use this software for their in-house systems. But we also have clients that want to rent our software. They don't want to buy it, they want to try it out. Then we have 2 different models, one where you can rent it and operate it yourself, and we also have a on-command solution where we actually take you to the defensible methodologies for the first time. We train you, we'll help you, and then after that you can learn how to do it yourself and move on to the right side of this model. Very important is that when we do this, and when you do this, you should have a defensible methodology. Technology without a defensible methodology is a certain recipe for disaster. You want to follow a methodology. You want everything you do to be auditable. You want everything defensible, and you want to have a full chain of custody. And you need to have both the software and the technology. And I think that's very, very important. So, from my point of view, how can you address the dark side of big data? First of all, get control over your eDiscovery data. That's a no-brainer. Again, it's a huge return of investment. There's very little risk. These systems can really help you to save a lot of money. Second, look for opportunities to do legacy data cleanup and defensible disposition projects as part of an overall, IT and other enterprise information archiving project. And third, if you are in a risky business, or you are aware, or you may do business in countries or locations or projects where there is a big risk, then you can also do automatic risk assessment. And if you want to know a little bit more about all of this, we have a lot of content that we wrote, some of it together with AIM, some just ZyLAB white papers, some with people from the EDRM, with George Sosha and other thought leaders in this space. Download the white papers, and it will show you how you can either bring eDiscovery in-house, how you can use content analytics for risk analysis, or how you can address the dark side of big data. That's what I wanted to say. Anything to add, David?
I think you've brought up some important technical points. When we talk about the legal and global issues as far as litigation goes, I think Jan's points are really critical on applying technology to these problems. Because, you look at the way that lawyers approach these problems, all the law schools on the planet could not produce enough lawyers to review this data. So the technology applications are key to getting this job done. There's simply no way you can do it without the technology. In the U.S. over the past year and a half, especially with the introduction of technology-assisted review, we've seen hyperbolic headlines such as, "Will computers replace your lawyer?" Usually in the mainstream press, not the legal press. But the key to remember is, sure, computers and technology are going to change the way that lawyers and paralegals do their jobs, but we're certainly not going to have the HAL 2001 nightmare where the computers take over. It's really key that everyone knows you've got to use these tools, and the tools will, frankly, help us cope with this dark side of big data.
Okay. Well, thank you very much. We've been listening to David Horrigan of 451 Research, and we've also been listening to Jan Scholtes of ZyLAB. I have a couple of questions coming in here, and just before time gets away from us, we're just going to push a survey out to you. It's going to open in a new window after the webinar. Just come back and answer the survey. Would greatly appreciate that. One question that I do want to touch on, Jan, you were talking a lot about, you were referencing that, a lot of businesses don't actually have records managers on staff anymore, and, the technology is certainly there, and the technology is excellent with the classification to help with all of this. But can both of you just briefly touch on, the concepts of records management with having the retention and disposition plans and schedules and employing, taxonomy structure so that your classification systems can work better and be functioning better. Can you talk to that side of just the planning that goes into this, even though you might not necessarily be doing on the front end, but those concepts are still needed?
Yeah, no, absolutely, and we do assist our clients with that process. Typically, what you have is we actually have examples of filing plans from small and large organizations, and typically what you do is you organize them by the department, and per department you look, okay, what type of documents are people working with, and then per document you're actually looking at what are the regulatory requirements to keep them, or when can you dispose the documents. And then this is like a tree structure, it's a hierarchical structure, and then once you have this global structure, structure in place, then it's very easy to make patterns and use machine learning and text mining and full text search to automatically classify and identify and detect these type of documents and map them into the right parts of the filing plan. Now, once they are in the filing plan, that's when somebody in the company has to execute the filing plan, making sure that the retention policies are followed and that whenever data can be destroyed, it has to be destroyed. And that's a responsibility that every company should not forget. And because we are running into companies that have perfectly well organized all their data, and then they forget about to do the retention, and then they have a legal hold, and then they find all these boxes of paper that should have been destroyed 15 years ago, and they didn't do it, and now suddenly these boxes are part of a legal hold. And so there's all these additional costs that were not necessary if the filing plan was properly executed. Now, if people are interested in that, we have a lot of examples and documents, and also explain it in layman terms, what it takes and how you do it. And you can do it the very hard way, according to like the DoD 5015.2 records management standards, but there are also a lot of more pragmatic approaches to doing records management. It's not that hard. You just need to start and then take it from there.
You know, from our legal industry perspective, we get the question all the time. Companies come to 451 Research to say, okay, we'd like to get your opinion on how we should operate, what the laws are. Not that we're giving legal advice today, but they also want to know what software applications would be best suited for what they want to do. And time again, from the end users, they say, okay, how long should I keep my email? And you hate to give them the lawyer's standard response, but it really is true. It depends. And what Jan is saying from the technical standpoint is really important here, because if you are an enterprise of any size, you've got varying statutes of limitation and regulations that are going to affect how long you keep the information, which is why the lesson from the Rambus case we discussed earlier is so important. You can't just go and have a shred day. That is always going to get you into trouble. You never want to say never, and you never want to say always. But in this case, you can almost say with absolute certainty that a shred day will always get you into trouble. What you've got to do is use the technology to comply with the various statute of limitation and regulations that you've got, and that's got to be ingrained in the records management policy. There once was a time where, you know, we talked about banker's boxes and paper documents earlier. You'd have filing cabinets, you'd go through them. It was an onerous task, but at least it was something that everyone could get a handle on for the most part. Now we really need the technology to help us, because we've got to comply in the United States with OSHA regulations. If we have offices in the European Union, EMEA, Asia, other places, we've got to know what those regulations are for where we're doing business. So the technology and the lawyers and the paralegals and IT staff working together, as we've said before in the hour, is really important, because you've got to comply with various deadlines. So one department may keep email for 2 years, another may keep spreadsheets, Word files, and email for 5 years. Some of them are as long as 20 years. So it's just important to use the technology to make sure you comply with the various deadlines.
But wouldn't you also say, because you're talking about saving document types according to a retention schedule, but what about the content that's in there, or it's more than just being paper and file types, because everything is
digital. Absolutely.
Most things are born digital today.
Yeah.
And email are records and documents. If you're not thinking of them as email as that extra thing to do, but that's just part of your document management, information management planning process.
No, but you have to look at the content. And if you have an email in a calendar item with a zipped PDF that's non-searchable, you have to make it searchable. And you know, that depends. You know, there's different types of technology, and the ZyLAB technology all comes from this. Our background is law enforcement and intel. So if it's there, we'll find it. And so you have to really look at the content of a document, and you have to use text mining to add additional semantic value to documents. And the more information you have, the better and more reliable you can make a decision on what's in the document and where it belongs in the filing plan.
Okay. I want to squeeze in another quick question in here, because someone asks about during the eDiscovery, the discovery process in general, are we creating more data by copying data from the existing legacy system to the discovery process?
Well, that depends. That depends. It's I'm not a lawyer, but that depends. What you want to sometimes with when you're under obligations of a pretrial discovery, you have to preserve your data, and the easiest way to preserve it is to copy the relevant data to a preservation server. So you only copy the relevant data, you don't copy everything. And then these servers, they can be anything, any cheap blade server. You don't need like very expensive systems. It's just hard disk systems. And what you do is you just copy it there. When you copy it, you may have to process it. So if it's PSTs, you have to look into the individual MSTs. There's all kind of rules there. You cannot just, give a PST to the other party, because what you want to make sure is that you take all the privileged and confidential information out, because it can result to all kind of other liability you don't want. And at a certain moment, you want to apply redaction, and then you want to do production, and lawyers do these productions in TIFF. And the reason why they do it in TIFF is that it also takes away a lot of hidden content that you don't want to disclose to opposing parties. And so this is really a whole process, and everything is done for a reason. But we try to, of course, limit the amount of data redundancy and data duplication as much as possible. Now, having said that, storage is cheap, and it's often cheaper to copy data than to try to do certain things in place, because if you have a legacy system, it may very well be that there are no APIs that you can allow you to do, for instance, a legal hold or something else in these old systems, because they just don't have the facility, and then it is easier to copy it.
I think Jan has made excellent points on this. I would add that, first of all, the listener's question is extremely astute, because I think in most jurisdictions, yes, by creating that repository, you are creating more data subject to discovery. However, that doesn't mean you shouldn't do it. In the United States, courts have said that data that is not reasonably accessible through costs, et cetera, is not necessarily discoverable in litigation and eDiscovery. However, that's not an excuse to say, okay, well, tell you what, I'm just going to leave it on an old legacy system. That way it's not reasonably accessible, so I won't have to produce it. That is not a winning argument. And what you can do by transferring the data to a newer system from a legacy system is really cut your cost, because you can get rid of the old legacy system so long as you're preserving that data. That is what we call defensible deletion, because you've moved it to a new server that's cheaper to access, cheaper technology, and you're going to run into an issue that at some point you may not be able to access the legacy data on that older legacy system. And in any case, it's going to be more expensive to get to the data, and you may very well have a court order ordering you to do it. So the best procedure is, even though you may be creating more discoverable data, move it to a newer system. You can get rid of the old system and cut your eDiscovery costs.
Well, thank you. I know we can keep talking for another hour. This is just a great conversation. Very much want to thank David Horrigan of 451 Research, Jan Scholtes of ZyLAB, and certainly thanks to ZyLAB for sponsoring our webinar today. We are out of time here. Thank you for sticking with us. Just see up on the screen, we have another webinar coming up later this month. And if you go to aim.org/webinars, you can see all of the calendar webinars that we have on our calendar coming up. And then this webinar is being recorded. It'll be available at aim.org/webinars on demand in just a day or two. Come back, listen to it again, invite your colleagues to listen to it. We also have our library of webinars on demand there available. And just as we're getting ready to end our webinar, I just do want to ask each of our presenters to give me, their key, that great takeaway or the key thought from our webinar today. And I would like to start with David Horrigan of 451 Research.
Great. Thanks so much. And once again, thanks for having me. It's always good to join you. I would, we started off with the title, The Dark Side of Big Data, and we wanted to point out some of the pitfalls you may have so you can be better prepared to face what you're going to have to do in discovery. Having said that, there's also a bright side to big data, and that is the way, as I said earlier on the call, how we really improve our performance, improve our productivity. And so I think the lessons I would take from this is evangelize to your entire organization. As our data show, there are some people who aren't finding this very important. know the jurisdictional differences, consult with your lawyers, talk to the people you're involved with, the people on the ground in your organizations, implement technology. That's going to be a big thing. Whatever vendor you choose, go in and get an application that's going to help you wade through this. The computers are not really going to take over as in HAL 2001. They're there to help you, and the technology can make this so much easier for everything you do. And thanks again for having me.
Thank you. And Jan Scholtes of ZyLAB, your closing thoughts?
I think that for every organization, really the first thing they should do is to get control over their eDiscovery data. That's really where you can make a lot of money or save a lot of money. Once you've done that, it will also be so much easier in your organization to push and to evangelize the cleaning up and the risk analysis of all of the dark sides of your data. If you try it the other way around, it will be much harder because people do not always see the need to spend money on being proactive. But if you try it through the eDiscovery routes, you can solve a lot of problems that companies have these days related to information governance, anything from records management to cleaning up legacy data, and even, you know, by finding the real gold nuggets there, you can also start thinking about real knowledge management instead of just, you know, keeping and analyzing data dumps.
Thank you. That's all we have time for today. Again, thanks to ZyLAB, our sponsor. For AIM, this is Teresa Resick, and we'll see you next time. And have a great day.
Thank you. Bye-bye.
Thanks again.